What we have now are sexy terms that are being used, whether by diplomats, whether by criminal justice actors, whether by politicians. And the sexy terms are, in order to address this crime, we need a holistic approach. Think how many times people have heard that. The most recent one was, well, we need a whole-of-government approach to deal with the problem of terrorism and to deal with the problem of transnational organized crime. Lately, we heard not only do we need a whole-of-government approach, in the last UN Security Council Resolution 2178 on foreign terrorist fighters, they talk about having a whole-of-nations approach. So that is an understanding that somewhere across the borders, there's a lack of cooperation that the countries have had to deal with. When we looked at the Paris attacks, there were other countries involved within the European Union. Greece was involved. Austria was involved. Germany was involved. Spain, to a certain degree, was involved. But none of those made it to the joint investigation team because countries still limit the way they share information with one another. So this is a challenge.
A couple of crimes were discussed whether they should be inserted into the Rome Statute alongside the 4 core crimes as you find them: genocide, war crimes, crimes against humanity, and aggression. And this was, for instance, drug crimes, international terrorism, mercenarism, and willful and severe damage to the environment. This was, however, finally then rejected by the majority because, as it was generally said, there was no necessarily no proof of international customary or treaty law for these crimes to have made it up to an international crime, a freestanding international crime. It was doubtful whether crimes like mercenarism would necessarily make it up to the gravity threshold of a core international crime. And finally, again, the argument, well, these transnational crimes are usually encompassed in our core international crimes, so that this was finally dropped.
If states do in fact behave in the way that they should in protecting, promoting human rights of their citizens and in preventing violations, then we will not have these crises in Darfur, in Burundi, etc., erupting. So that's the starting point.
Why does it take so long? And what does it take? It takes the action of civil society who continue to believe in an international legal framework. And that means that we have to use these imperfect tools as part of our toolbox to push forward an agenda for justice.
Quite often, if there are violations of such rights, we tend to focus on one single actor. And we tend to think, like, because I've been working in conflict, it's to do with the troops or it's to do with the rebels. And that is wrong, because as we have just seen in South Sudan, quite often it's the governments. And if the state actors are not directly seen to be involved, they tend to be involved behind the scenes. So the role of the group is basically to bring more knowledge and understanding of the nexus between the various actors leading to a particular human rights violation.
Africa was the first continent. 5 countries in Africa appealed to the International Criminal Court to help them investigate serious crimes they were facing from armed rebel groups. So previously they were not able to do that. Now they got the help. So if they are unable to investigate and prosecute, we have this permanent court. It's of great benefit to Africa, and I think proper information and countering some of the propaganda that is going on, for instance, that the ICC is targeting Africa only, all this will help educate people on why we should appreciate and value the world's first permanent criminal court.
We were practitioners, so we reacted. Yeah. We have to do something.